In view of the above discussions, this court has no hesitation to hold that the prosecution has failed to prove the act of the accused administering a blow to the victim and has also failed to bring home the charges that the accused caused the victim to fall off the scooty with the knowledge that such a fall would cause injury which would likely result in death or had the intention to cause such injury which was likely to cause death. In the result, the judgment and the order of the Lonett Trial Court is set aside and the accused is acquitted of the charges. He is to be set at liberty forthwith if not required in any other case.
Oblige, Your Lordship.
Yes. Yes.
May I seek Your Lordship indulgence in mentioning item number 10 and 11, part 2, hearing list.
Item number 10 in the part 2 list.
Lordship, I am on behalf of my senior counsel for the appellant, and if this matter may come up after a week, my lord.
After a week,
Yes, my lord.
you are appearing for the appellant?
Yes, I'm appearing on behalf of my senior, Mr. Johnny L. Tauchong.
Okay. On a request made on behalf of Mr. Johnny L. Tauchong, list this matter again after a week in the hearing list. Yes.
Much obliged, Your Lordship.
May I seek Your Lordship indulgence in mentioning part 2, item number 14.
14. Yes.
I'm appearing on behalf of my senior, Bilaram Nehemi. Unfortunately, she has to attend the bereavement of her families.
Okay.
So if the matter may be taken after next week,
A mention has been made of this matter on account of bereavement in the family of the Learned Amicus Curiae, full stop. Let this matter be listed after 2 weeks, or 1 week, 2 weeks, on a date to be fixed by the registry in the hearing list.
I seek Your Lordship indulgence in making mention unlisted item.
Unlisted. What is the urgency?
Your Lordship, this is a criminal petition and we want bail modification. Bail is already granted on September, but we cannot fulfill the bail condition and cannot execute the bail bond.
You filed it, you have already filed it.
Yes, my lord.
Can it come up before 1 o'clock? Huh? Bring it before 1 o'clock.
Your Lordship, if the matter may be listed on Monday.
On Monday, you're asking for Monday. Okay, allowed. Monday allowed. I thought it was for today. Monday allowed.
Submission item 2.
Regarding this item, Lordship, if I may now be granted 3 weeks' time for filing affidavit, Lordship. I received instruction, but which are now still incomplete. So I have now to seek for some more information on that, my lord.
Lordship, they have taken quite some time for filing those affidavits. So if another 1 week can be given, Lordship, if 3
Then 2
weeks
weeks,
is
Lordship.
too long.
TCR, is it received? TCR received, yes. Is it about?
In a trial court, Lordship, the petitioner and the 2 other accused were
Okay, financial.
yes.
My lord. Yes, the petitioner here, the Lordship, was earlier employee of the Mizoram Rural Bank, Lordship.
If it is 3 weeks, it goes to January. Does it
Yes,
not?
Lordship.
My lord.
So
That
if-
is what she is saying.
yes.
It's up to your lordship. I need some more time.
This
madam,
matter
that's all.
can be listed again next week, Lordship, within that. They have taken quite some
week.
time.
1 week.
If he's waiting for further instructions, next week is not going to help him. So we can have it in the second week of December for him to file the affidavit.
Madam.
Yes, Your
Once he
Lordship.
files the affidavit, you come up with your reply if you want, and we can have it.
Yes, your lordship.
Yes, Your Lordship.
Mr. So-and-so on a council appearing for the
Respondent
respondent,
number 2.
number 2, has submitted that although he received instructions, the same are not complete, and he would require further instructions to file the response to the petition, full stop. Lord and counsel appearing for the petitioner has objected, saying that enough time has already been given to the respondents, full stop. The Lord and counsel, the respondents are accommodated for another week to file their response, full stop. List this matter again on the 5th of December 2025, by which time the respondent shall file their response.
Lordship, can we have it on 8 instead of Friday, madam?
Yes, make it 8.
Obliged, your lordship.
I see your lordship's indulgence, your lordship, in item 3, 4, and 5. They're all connected matters. I was supposed to take steps on respondent number 3. If I may be granted, your lordship, permission to take service through Dusty on 3, 4, and in items 3, 4, and 5, upon the respondent number 3. He's the competent authority appointed by the railway authorities.
Who are the 4 and 5?
Judge, in fact, this is an application, since the appointed arbitrator had withdrawn himself from the proceedings. This is a writ petition for a direction to the respondents 1 and 2 to appoint a substitute arbitrator under the Railways Act.
Yes, Mr. A.R. Malhotra, learned counsel, appearing for the petitioners, has prayed that he may be allowed to take steps by Dusty on the respondent number 3. Full stop. The prayer not being objected to by the learned counsel for the respondents, comma. The petitioner is granted permission to take steps by Dusty, comma, to be routed through the registry of this court upon the respondent number 3 within a period of 1 week from today. Full stop. The petitioner shall then file an affidavit regarding the service of notice on the respondent number 3. Full stop. Registry to list this case thereafter on a date to be fixed by the registry with the affidavit to be filed.
In the meantime, respondent 1 and 2 have to file the affidavit.
But I'm still awaited comment, then I may be given 3 weeks time.
Ms. Swensel and counsel appearing for the respondents has submitted that she still awaits the instructions from the respondents. Full stop. The matter relates to the appointment of a substitute arbitrator in when the earlier arbitrator has withdrawn himself from the case. Full stop. The respondents are permitted to file their response by the next date of listing.
Amu.
Item 4.
I think 3, 4, and 5
Similar.
all similar.
3, 4.
Similar.
Item 6.
Yes.
Yes.
I've received a copy of the affidavit, additional affidavit. Have you filed?
Have you filed it?
Today we have filed.
Today you are filing it.
Service copy has already done.
When do you want it?
Service copy has.
When do you want it?
Senior counsel is like
Your name, sir?
A. Bharali,
A. Bharali. Mr. A. Bharali, learned counsel,
appearing for on behalf of SK Committee.
appearing on behalf of Mr. S.K. Medi Kumar, learned CGSE, has submitted that the additional affidavit is in the process of filing and will be filed today itself. Full stop. Mr. A.R. Malhotra, learned counsel, appearing for the appellants, oblique
Your- yes.
respondent in this, huh? Appearing for the respondents, has submitted that he has received a copy of the affidavit, full stop. List the matter again after 2 weeks on a date to be fixed by the registry,
Treat the matter
along with the affidavit filed by the applicants.
Your Worship, it can come up on 22nd of January.
Okay, then let it be on the 22nd of January, huh? List this matter again on the 22nd of January. Cut out that after 2 weeks part.
I'm willing.
Yes. Item 7.
Why this I?
Lordship, in this matter, respondent number 18 and 19, they are newly implemented, right, order 28/8/2025. We are the intervener. We are not initially a party in the writ petition, and we have filed an implement, and that was allowed on 28/8/2025. And we have filed an application for modification of the order dated 14/8/2025, wherein this honorable court has passed an interim order.
What is the interim order?
The order is on page 22, that is on Annexure 2.
Page 20.
22 is not, no, page 20, Lordship. The effective portion, the relevant portion is on page 21, last para.
Page
21.
So why
Lordship,
modify this?
yes, Lordship. Lordship,
Why should we modify this?
Lordship, there's the applicant herein in page number 22, that is the impugn notification. The serial number 9 is petitioner number 2, and serial number 12 is petitioner number 1. Since I've already mentioned that they are not initially a party in the writ petition.
So now you are parties.
Yes, we are a party now, and Lordship, they are not aggrieved with the appointment of to the post of this surveyor. Lordship, and our rights have been affected.
No. It says that whereby private respondents have been recommended for appointed under the Land and
Yes.
Revenue Settlement for the post of surveyor.
Yes, Lordship, all the other candidates here in the impugn notification are a party are the private parties in the and they are arrayed as a respondent.
So now you have come in as respondents.
Lordship, since
Argue on the
so
matter.
far as the modification is concerned,
If you can show us that you have that 1-year course, we'll modify it.
no, Lordship, our qualification and our they have not disputed our qualification. We have
You show us that you have the survey, you have the 1-year course.
Lordship,
This stay order has been given only
Yes.
because it is the allegation of the petitioners that
Yes.
persons without the 1-year survey course are
we
sought to
have
be
the
appointed.
1-year survey
You have
course.
it. Where is
Yes.
it? Where is that? Page?
Page 48 and 49. 48 to 51, Your Worship.
This 49, Lordship, page 48.
Page 48.
This is petitioner number 2.
So you have got political science.
And the next
Where is
page,
it?
Lordship, page 49.
Yes, what do you say about these
Your
two?
Worship, yes, Your Worship, in fact, initially, when we filed the writ petition, we did not impede them because we were sure that they had the qualification required
They had
as
the
per the recruitment rules. But it was my mistake when the interim order was passed. We should have said to the extent of the respondents, not the
Okay.
others.
So
who were
we
not
can allow
included.
this?
Yes.
There's no difficulty.
And,
Yes.
unless the private respondents have
Oh,
something
yes,
to
the
say.
other private respondents. Yes, what do you
So, my lord, in this case, the private respondents number 6 to 17, my lord. In fact, they also have, I'm not going to say, my lord, that the stay order should be vacated for us also today. In fact, they also have this 1-year course on surveyor, my lord. In fact, they also have, because they are all bachelors of engineering, and one of the course they have, my lord, is the subject of surveyor. So that course is there, and that will be debated, my lord. We will argue that during the course of
But
the
they
hearing.
have a direct certificate on that.
So my humble prayer at this stage is, my lord, we have no objection as such to this application filed by them. But my lord, let this application, let the order be subject to the writ petition. And my lord, one thing that can happen is, because we are in the list, all of us are in the list, and some of these private respondents are in are in the list from serial number 1 to 8 before these people, my lord, before these applicants.
If you don't have the qualification, nothing remains.
No, if we
You will
lose
not
the
be
case,
there in the
if
list.
we lose the case, my lord, nothing remains.
And if you have the course, then whether or not they are appointed, it will be upon the respondents to will dismiss the writ petition. It will be upon the respondents to do what they want to do.
No, so my humble
The
prayer,
seniority will not be affected because
Yes.
it was only under the orders of the court that you were not appointed. That will be a prayer when you make in the final disposal of the writ petition, not today.
but my lord, can this be reflected, my lord? Not prejudice them and all
We'll do
that.
that, yes.
Your Worship, in fact, notice was issued in August. Where in November, they received notice long time back. If they're in a hurry and there is urgency in the petition, they should file the affidavit and the matter can be
We'll
disposed
file it.
of.
We'll file it, my lord. In fact, my lord, we are waiting for the state government also. MPSC also are yet to file their
That is
affidavit. my
a very important aspect of filing an affidavit. What does the government say? Right? Okay. Heard Ms. So-and-so learned counsel appearing for the applicant in this interlocutory application. This order is in the interlocutory application, okay? Also heard Mr. A. Malhotra, learned counsel appearing for the writ petitioner, opposite parties. Full stop. Ms. So-and-so appears for the, Mr. So-and-so appears for the state respondents.
No, state respondents.
For the private respondents, Ms. So-and-so appears for the state respondents, full stop. This IA has been filed by the applicants who had intervened in this writ petition and were arrayed as respondent number
18 and 19.
18 and 19, full stop. It is submitted that originally the applicants had not been arrayed in the writ petition as respondents, full stop. The two applicants in this IA submit that the interim order dated 14/8/2025 had been passed by this court. Where is that order?
Page number 20.
20 years, had been passed by this court, restraining the respondent authorities from making any appointment, on the ground that the respondents did not have the qualification of a one-year survey course from any government recognized institution amongst other qualification for the post, for being appointed to the post of surveyor as given in the
The recruitment.
the recruitment notice, full stop. The learned counsel for the applicant has submitted that these two applicants, who were arrayed as the candidate number 9 and 12 in the impugned notification dated 37/2025 have the requisite qualification of 2 years course under the Mizoram Council for Vocational Training, and as such, the ground taken in the writ petition would not be applicable to the present applicants, full stop. Mr. A.R. Malhotra, in his usual fairness, has submitted that since these two since the applicants were having the required qualification of a minimum 1 year certificate course, 1 year survey course from a government recognized institution, they were not arrayed as respondents in the writ petition, full stop. He has submitted that there be no objection for allowing the appointment of the applicants subject to outcome of the writ petition, full stop. The learned counsel appearing for the opposite party's number. Yes, your opposite party's number what?
My lord, opposite parties number 6 to 17, my lord.
6 to 17 has submitted that there would be no objection for allowing this interlocutory application for appointment of the applicant number 1 and 2, keeping the same subject to outcome of the writ petition, since some of the opposite parties have been arrayed higher in the select list
Correct.
published by the respondent authorities, full stop. The learned counsel appearing for the state respondents has also submitted that when the applicants are admittedly having the requisite qualification, there can be no ground to withhold their appointment during pendency of the writ petition, full stop. Having regard to the submissions made by the learned counsel for the contesting parties, and also having regard to the interim order dated, what was the date of the interim order?
14-8.
14/8 2025, and the reasons behind passing such IA number 150 of 2025. Where is your clear clause? Okay, I'm sorry. Yes. What did I say? And the reasons behind passing of the same, this interlocutory application is allowed to the extent that the respondent state authorities would be at liberty to appoint the applicant number 1 and 2, who are arrayed at serial number 9 and 12 in the select list to the post of surveyor, keeping such appointment subject to the outcome of the writ petition. Accordingly, I stands disposed of. It is made clear that the respondents are restrained from making any appointments to any other candidate from the select list for the post of surveyor without further leave of this court.
And my lord, will it be possible, my lord, that they will be at liberty to make appointments to the applicants, my lord, subject to the writ petition, and also, my lord, subject to seniority in case.
That will come when you get an order in the writ petition, because they made it subject to outcome of the writ petition. Outcome of the writ petition will say appointments were held up due to interim orders of this court. Therefore, that should not affect the seniority in accordance with the merit of the candidates of the select list.
Worship, in the main writ petition, an order may be passed in the main writ petition.
For
They're seeking time. They're seeking time for filing counter.
what was the last order?
My lord, this is only the second occasion, my lord.
In the
This
main
is, this is the second time we have.
Okay, in the writ petition you take down, this writ petition by order dated 6/10/2025 was directed to be listed in the following week, allowing time to the respondent number 6 and 7 to file their affidavit in opposition, full stop. List this matter again after 2 weeks on a request, on a prayer made by the learned counsel for the respondents for accommodation, allowing them the opportunity to file their affidavit in opposition, full stop. State has filed the affidavit.
No, my lord.
Up to item 7.
Your Worship, in this matter, the
See,
additional AG was directed to produce the case diaries. I think he has received them. The case diary of the original case IO, as well as the special investigation team.
State Police. What is the matter about?
No, but the matter is regarding an direction for the investigation to be conducted by the CBI. The brother of the petitioner had died while on duty, but our case is that he was murdered by his colleagues. But the police report stated that it was a case of suicide. So
He was working with the
in the Assam
Assam
Rifles.
Rifles.
The Assam Rifles. So while on duty, he was found dead, shot by his own duty gun, but the finding of the case IO was that it was a case of suicide. We challenged the findings. The Honorable Court further investigation to be conducted by the SIT. SIT again said that it is a case of suicide. So we have challenged the finding and we have prayed for investigation to be conducted by the CBI.
Was this man involved in trying to make allegations of some bribery in the Assam Rifles by the top brass? Was it something like that?
Not.
Something else.
Doctor, okay, sir. Next week.
And because I have to be a little careful when I take up matters where the Assam Rifle or the other paramilitary forces are involved. There have been a lot of cases where I have advised.
Okay.
Not to the department, to the private parties. So, yes, you have the CD.
I have been furnished a copy of the CDs, my lord, case diary. And I've been given only one copy.
Acha.
I'll have to make extra copy for the court and for the petitioner as well.
By the last order dated 992025, comma, the learned additional advocate general appearing for the respondent number 1 to 5 and 8 had been given time to produce the case diary with regard to the investigation conducted into the death of the conducted by the state police. Full stop. It has been submitted today that only a single copy of the case diary has been submitted to the office of the additional advocate general, and some accommodation is sought for to make copies of the same and furnish it to the counsel for the petitioner, and also to furnish it to produce it before the court. Full stop. Accordingly, list this matter again on
After a week, my lord.
after a week on a date to be fixed by the registry. Yes.
Obliged, my lord.
Item 13.
Yeah, this matter may come up after a week. Your Worship.
At the prayer made by Mr. A.R. Malhotra, learned counsel, appearing for the appellants. So this matter be listed after a week.
Even 17. Your Worship. Similar.
Same order in 17. Any more matters? Eleven and 11, 13, 16 remaining, na? 11, someone mentioned item 10. So what about 11? I think it's the same. 11 is after a week. What about 13? 13, 1, 3. Also 1 week done. 16? Huh? And 17 has been mentioned. What to do about 16? Okay, in item number 16, take down. None appears for the parties on call. Should we say that? None appears for the parties on call, full stop. List this matter in the next week in the hearing list. Done? All done? Thank you.